proceedings on the second round, where I believe that the relaying of those charges is completely without justification and wrong. So thank you very much. That's all I want to say.
Thank you very much, Mr. Jagru Singh. I would now like to call to the microphone a person that I think everybody in Trinidad and Tobago would know, Mr. Prakash Ramadan.
Thank you, Mr. Maharaj. Good morning, everyone. Many of us, why that I have involved myself in a matter where Mr. Baksh has been criminally charged. I am of the view, like most right-thinking citizens, that our presumption of innocence in our Constitution must be respected. And I saw almost an attack on a citizen, notwithstanding who he is, in a way that presumed guilt in a criminal matter. And if for any other reason, that I think is the most significant issue that I have involved myself in this matter with. We are all entitled to presumption of innocence, no matter who you are in this country. I've heard allegations, and Mr. Maharaj will speak to this, in relation to the arbitration and the false information that we have been given. I believe in due process, and that is why my colleague Mr. Singh, Mr. Rupla, of course our dear senior Mr. Maharaj, has always stood for every citizen, whether they are high or low in society. And if there seems to be developed in this country a belief that once you occupy a certain level in society, that you can do no right, and that everything you do is seen through the lens of corruption and improper motives, and that you are not entitled to justice. So, Mr. Maharaj, I congratulate you for this press conference so that we put things in order. Because too often we hear rumors, we hear allegations, and people form a view that a person is guilty without due process. So I thank you for it.
Thank you very much. In the order I'm dealing first with the criminal charges, I'll call Mr. Michael Ruplal, attorney at law.
Good morning, everyone, members of the media, listeners, viewers, everyone present today. I think both Mr. Singh and Mr. Ramda have said a lot. I've been involved in this matter since inception, since Mr. Baksh and Mr. Ramda.
Going through that process with them, what I can see, and I'm looking forward to the press conference and what Senior has to say this morning, but what can I say from my own knowledge is that this appears to be, an orchestrated persecution of Mr. Baksh and his family. And like my colleagues and everyone here, I'm sure, we look forward to bringing finality to all of these proceedings, both the civil proceedings, the arbitration and the criminal proceedings, so there could be vindication of Mr. Baksh and his family. So, thank you very much.
Thank you very much, Mr. Ruplal. The next person is Mr. Ronnie Bisessa. He is an attorney at law. He has been helping me and the legal team in respect of all the matters with Mr. Baksh, but in particular with the arbitration proceedings which are due to be heard and with the attempts which we have made to get Petrotrin to do justice. Mr. Ronnie Bisessa is part of a legal team, and I should let you know that when I saw the injustice which was being done to Mr. Baksh by Petrotrin, I decided that I would move every stone in order to prove to the country that Mr. Baksh and A&V was totally innocent of the allegation. I call Mr. Ronnie Bisessa.
Thank you very much, Mr. Maharaj, for that introduction. I am Mr. Maharaj's junior in respect of the arbitration proceedings which are going to be convened in January 2020. Ordinarily, arbitration proceedings are private and confidential between the parties. This matter, however, has a very public character and element. On the 9th of November 2017, Petrotrin issued a media release saying to everyone that the internal audit report and its findings were confirmed by various independent reports. That, unfortunately, was a completely inaccurate and unreliable statement. And having raised the matter in the public domain, it's only appropriate that A&V uses the public domain to be able to correct the record. I'm very happy to be part of this team, and I feel fortified that what Mr. Maharaj is presenting to you today would demonstrate that unequivocally and unambiguously that A&V has been ill-treated by Petrotrin. Thank you very much.
Thank you very much, gentlemen. I would first like to start by saying that the facts of the case in which Petrotrin has terminated the contract with A&V, the oil producing contract which A&V had with Petrotrin, reminds me of a case which I took up when I was a much younger lawyer. And that was in 1975. In 1975, Texaco decided to, they had a case, there was a case against Texaco in respect of a fire on the Pointe-a-Pierre River. 4 persons lost their homes, and we had this case in court, and the judge threw out the case without a hearing. But on the facts of the case also, Texaco, as it was then named, were using the court process to really put pressure on these poor people. And I decided that whatever it takes, that I would ensure that those people who lost their homes on the banks of the Pointe-a-Pierre River would get justice. In that struggle, I had to have a quarrel with the judge, Justice Sonny Maharaj, and I accused him of unjudicial conduct. And he jailed me for 7 days simple imprisonment. And that contempt conviction was reversed by the Privy Council after a long battle. And I refused to apologize to the judge. But at the end, I saw that not only the people got justice who had lost their homes, but the legal profession got justice, because my stand was a stand for the independence and fearlessness of the legal profession, because lawyers must not be sycophants and subservient to judges. They must stand up for their clients. They must also stand up to governments, stand up to state corporations if they are doing injustice to people. Well, the purpose of this press conference is really to try to make the public understand what has happened with this A&V oil contract. Now, to give you a little idea, as some background to what I'm going to tell you, A&V had a contract with Petrotrin. A&V had to drill and produce crude oil and supply to Petrotrin. Petrotrin would pay for that oil. Petrotrin decided that based on its measurement system, not on actual evidence, it had no actual evidence that A&V was involved in any fraudulent activity, but based on its measurement system of how it received the oil, and it received oil from other independent operators, Petrotrin assumed that since A&V was producing a lot of oil, that A&V overstated its production of the oil to Petrotrin. And it assumed and it inferred and it implied that A&V inflated its supply of oil to Petrotrin. And that is how these allegations of fake oil came into play, not on the basis of actual evidence, but on the basis of what Petrotrin assumed. Now I want to tell you, in this matter, there is no question of fake oil. This is a case of A&V supplying real crude oil. And this is a case of Petrotrin having a fake defense to use fake oil as a means of trying not to pay A&V. So let me see how I can explain this to you. Petrotrin had a contract with A&V, as I said, for A&V to sell Petrotrin crude oil. There was an internal audit report prepared by the audit department of Petrotrin, in which the data stated that A&V overstated the volume of crude oil it sold to Petrotrin. Based on the contents of that report, Petrotrin started to withhold payments which were due to A&V for A&V supplying the oil to Petrotrin. A few days later, after Petrotrin got sight of that internal audit report, a supplemental internal audit report, which was prepared by the audit department of Petrotrin and which was submitted to Petrotrin, stated that the data which the internal audit report had and which formed the basis of the findings against A&V were inaccurate and unreliable. So a few days after Petrotrin got the internal audit report, there was another report from the audit department called a supplemental internal audit report stating that the data in that report, the first report, was inaccurate and unreliable. The supplemental internal audit report concluded that the measurement system and the measurement procedures of crude oil which Petrotrin used when independent contractors sold oil to Petrotrin were wholly inaccurate and unreliable. The audit department of Petrotrin stated that Petrotrin did not comply with the standard operating procedures in measuring the oil. Some of the contents of the internal audit report were published by the political leader of the opposition at a political meeting on the 10th of September 2017. Those statements allege, among other things, that A&V supplied fake oil to Petrotrin based on that internal audit report. Obviously, the leader was basing her comments on the internal audit report. And based on that report, A&V would have fraudulently collected $95 million because it overstated the volume of crude oil it sold to Petrotrin. So you would see that serious allegations were being made against A&V, and you would have thought that Petrotrin had a duty in respect of these serious allegations being made public to ensure that it conducted proper inquiries before it made a finding against A&V. These statements which were made to the public caused other persons in the public to make defamatory statements against A&V. And those defamatory statements have caused irreparable damage to the company, its business reputation, and the personal reputation of the owners and members and the family of the owners. The reports and information which Petrotrin has in its possession now have been seen recently by A&V lawyers, and they demonstrate that Petrotrin ought not to have terminated the contract. And I will go into some of this information with you. This information also shows that Petrotrin, after the contract was terminated, requested reports from its engineers and experts and from other experts, and those reports and information all show that there was no justification for Petrotrin to terminate the contract. I would also discuss with you later a PowerPoint presentation prepared by the engineers and experts of Petrotrin, which was presented to Petrotrin and which showed that the oil wells which were being operated by A&V at the Catskill field had the necessary oil reservoir capacity to produce the volume of oil which A&V sold to Petrotrin. I would also show you that Petrotrin's records showed that A&V had the pump with the necessary capacity to pump the volume of oil to Petrotrin, demonstrated that A&V had the capacity not only to produce the oil, but to pump the oil to Petrotrin. The basis of the case of Petrotrin against A&V was that its wells at the Catskill field did not have the capacity to produce the oil, and that A&V did not have the capacity to pump the volume of oil. Petrotrin's own evidence shows to the contrary, that it could have produced the oil and it did have the capacity. The information which A&V's lawyers recently saw, therefore, show beyond a reasonable doubt that A&V did not supply fake oil as alleged by Petrotrin. On the contrary, A&V supplied real crude oil, and the evidence which Petrotrin has shows that Petrotrin's case against AV is really a fake defense, and this fake defense by Petrotrin is being used to avoid paying AV for the supply of real oil. A&V has the right through its lawyers to make public the contents of the report and the information which Petrotrin has, because those reports and information show that Petrotrin knew that it did not have evidence that A&V sold fake oil to Petrotrin. Further, Petrotrin knew that it did not have any basis to terminate the contract with A&V. In addition, based on the reports and information which A&V lawyers now have, Petrotrin, after the termination of the contract, had evidence to show that it had a duty to restore the contract to A&V. Petrotrin is a state-owned company, and therefore it has a responsibility to act in good faith towards A&V in its contractual obligations to A&V. It has a duty not to dishonor the terms of the contract with A&V, and it also has a duty not to use frivolous reasons to prevent it from paying monies which are due to A&V. It is important for state companies like Petrotrin, which have contracts with the private sector, to understand that they have a responsibility to honor the terms of their contracts and to perform their obligations in good faith. State corporations ought not to use its powers to prevent paying monies to the private sector which are due and owing pursuant to the terms of their contract. State companies must not use the courts for the purpose of delaying payments to the private sector in respect of their contracts with the private sector. State companies which employ that strategy are not only dishonoring their contractual obligations, but they are engaging in action which negatively impact on the private sector investment in our country, and this can also have adverse effects on the national economy. Serious questions arise about the conduct of the then board of directors of Petrotrin in its decision to terminate its contract with A&V. The board did not conduct proper and/or adequate inquiries before it terminated or authorized the termination of the contract. The board acted on uninvestigated data as stated in the internal audit report, as stated in the supplemental internal audit report, and it blindly followed the inaccurate and unreliable data in that report. The board ignored the contents of the supplemental internal audit report, which undermined the findings of the internal audit report. The board ignored those findings and proceeded to terminate the contract. The board ignored the reports and information of Petrotrin's engineers and experts which were given to it after the termination of the contract, and it failed in its duty to restore the contract after its termination. Petrotrin's investigations. Petrotrin made a public statement that it was taking steps to have independent investigations done in respect of the internal audit report. Petrotrin subsequently announced that based on those investigations, which were done by both Kroll Consulting Limited and Gaffney Klein and Associates, these are two international companies, it decided to terminate A&V's contract. It is now known by A&V's lawyers from the information they recently got that Gaffney Klein did not conduct its own investigation. Gaffney Klein instead relied on the data contained in the internal audit report to make its findings. You would recall that I said earlier that Petrotrin's own supplemental internal audit report stated that the data in the internal audit report was inaccurate and unreliable. So the Gaffney-Klein report was based on inaccurate and unreliable data. But Petrotrin never told us that and never told the public that. Petrotrin has not given us a copy of the Kroll report, notwithstanding several requests we made for Petrotrin to supply a copy of that report. Petrotrin, however, relied on the Kroll report and the Klein report for it to terminate A&V's contract, but it decided not to provide us with copies of the report. It also did not give us a copy of the Klein report, but we obtained a copy of the Klein report and we have that report in our possession. But we have not seen the Kroll report. It is clear from all the evidence that the then board of directors had, when it made its decision to terminate A&V's contract, had the internal audit report, had the supplemental internal audit report which said that the data was inaccurate and unreliable, had the Gaffney-Klein report which relied upon the data in the internal audit report and which was said by the audit department of Petrotrin that the data was unreliable and inaccurate. So Petrotrin board of directors ought to have known that to terminate the contract would have been not proper. The board of directors, however, went ahead and decided to terminate the contract. And during that period of time, refusing to disclose to A&V and its lawyers any of these reports and any information or report it was relying upon to terminate the contract. So it became very suspicious to us then that Petrotrin was hiding something. It became clear to us then that there was a cover-up and that for some reason it was decided that this field had to be taken away from A&V and probably given to somebody else. It became clear to us then that the whole behavior of the then Petrotrin board was suspicious. I would now deal with the measurement process which Petrotrin used to measure the crude oil which was sold to it by independent contractors like A&V. I would thereafter deal with the other reports which A&V lawyers recently received, which show that after the contract was terminated, Petrotrin would have known that the data was unreliable and that A&V had the necessary reservoir capacity to supply the oil, and A&V had the necessary pump capacity to pump the oil to Petrotrin. So there was no basis for Petrotrin assuming that A&V overstated its production. The measurement process which Petrotrin used is as follows. A&V drilled the wells at the Catskill field to produce the crude oil, which is then stored in large tanks on the Catskill field. By a custody transfer process done in the presence of Petrotrin's employees and A&V employees, using custody transfer tickets, the crude oil is transferred from the custody of A&V into the custody of Petrotrin. The crude oil is then pumped through Petrotrin's pipelines to Pointe-à-Pitre. Other independent contractors follow the same process for the transfer of their crude oil into Petrotrin's custody at Pointe-à-Pitre. Petrotrin at Pointe-à-Pitre measures the quantity of oil received and compares these volumes with the volumes produced by independent contractors from the various fees pursuant to the custody transfer process. Petrotrin's case of overstatement. Petrotrin's case against A&V of overstatement in the supply of crude oil is not based on any evidence to show that A&V actually overstated its production and sale of crude oil to Petrotrin. Petrotrin's case is based on its records of the measurements of the crude oil supplied, and these measurements showed large variances between the volumes of crude oil sold to it and pumped from the fields with the volumes received by it at point-of-pay. Petrotrin blamed A&V for this alleged shortfall, but Petrotrin failed to take into account that its own measurement systems were found by its own audit department in the supplemental internal audit report to be inaccurate and unreliable. Petrotrin assumed that since A&V was the largest producer of crude oil in the Catskill field, that A&V overstated its production, which accounted for the variances. Petrotrin did not have any actual evidence that A&V overstated its production, but Petrotrin assumed and inferred that from the variances that there was overstatement of the crude oil supply. In support of Petrotrin's assumption, Petrotrin alleged that the Catskill field, that is the name of the field which A&V operated its wells from, did not have the reservoir capacity to produce the volume of crude oil that A&V sold to Petrotrin. And secondly, A&V's own sale pumps did not have the capacity to pump the hourly volume of oil it sold to Petrotrin. So Petrotrin was saying that I am assuming this because you are supplying a lot of oil, you are saying you are supplying a lot of oil, but I am backing that up with because I can prove that the field that you have and the wells that you have, they do not have the capacity to produce the oils that you are saying, the oil that you are saying you produce. And further, they are saying that you do not have the pump. There is no pump that you have could show that it could pump that volume of oil. So let's see what happened. Based on the report of the PowerPoint presentation, which I stated I will discuss with you later. Now this was a PowerPoint presentation prepared by Petrotrin's engineers and experts, and which examine all of the matters in this case. The PowerPoint presentation report, which was prepared by engineers and experts of Petrotrin and which was presented to Petrotrin, showed that the Catskill field had the reservoir capacity for A&V to supply the quantity of oil A&V stated it sold to Petrotrin. So this evidence, which is in Petrotrin's position, which we have seen, which we have access to, which we can prove before the arbitrator, which we can prove to the country, shows that Petrotrin has evidence that the Catskill field, and in particular the area of the field which A&V was operating at wells, has the oil reservoir capacity to produce the oil A&V said it produced and sold to Petrotrin. And Petrotrin has records of the pump that A&V had, because during the contract all these things were being inspected. They are processed for inspection. Record of the pump and the capacity of the pump. And Petrotrin's evidence would show that A&V had the pump capacity to pump this oil. So the foundation pillars of Petrotrin's case against A&V has been demolished and destroyed. Petrotrin's records also show that A&V at the material time used a pump with a capacity to pump over 400 barrels of oil per hour, which was more than enough capacity to pump the volume of oil A&V sold to Petrotrin. Petrotrin's case against A&V, its case of assumption, also relied on its measurement systems of the crude oil supplied by A&V to Petrotrin. And Petrotrin was relying on this measurement system to say that, to assume that A&V overstated its supply of oil to Petrotrin. But you will recall Petrotrin's own audit department in the supplemental audit report said that the measurement system was inaccurate and was unreliable, and I would show you other reports which Petrotrin got subsequent to that maintained that. A&V's lawyers pointed out to Petrotrin before it terminated the contract that Petrotrin's own reports showed that the data which it relied on to terminate the contract was inaccurate and unreliable. Notwithstanding the evidence from its own audit department, Petrotrin proceeded to terminate the contract. A&V's lawyers, as already stated, recently got information, and one such information is a PowerPoint presentation also already referred to about the Catskill field. Before dealing with the reports of Petrotrin and other information which A&V lawyers recently got, I would like to deal with some of the history of the matter, which showed the attempts made by A&V for Petrotrin to either show to it or to show to the court the truth of these matters. And you would see that although Petrotrin had this information when the matter was before the High Court and the Court of Appeal and the Privy Council, this information was not disclosed. The media would recall that after the publication of the internal audit report, A&V's lawyers visited the Catskill field with members of the media present, and they were shown A&V's large number of operating oil wells, A&V's large capacity of storage tanks, A&V's massive investments in infrastructure, equipment and machinery. The estimated investment of A&V was over $1.1 billion over the last 9 years to achieve high production of volumes consistent with the aggressive drilling program between 2016 to 2017. A&V, as part of its aggressive drilling program, relied on the opinions of highly qualified petroleum engineers and geologists, and the most recent surveys of the Catskill field to undertake cluster drilling programs, by which 5 to 6 wells were drilled in close proximity to each other at the same time. So when we went on the field, we saw, instead of seeing one pump in an area pumping, we saw 5 pumps in the same area. So that's what you call a cluster of wells. So you had all these clusters of wells being pumped at the same time. So you would expect that there will be greater production of oil if you have a clusters of wells like that pumping at the same time, instead of having one pump, as you normally see. A&V expended large sums of monies in purchasing equipment and machinery in order to extract the highest volumes of oil. A&V invested its monies in ensuring that the wells could produce oil to the maximum. He brought the technology, he brought the expertise, he brought whatever was required. And you would like to know that since Petrotrin took over the field, after A&V was put out of the field, the figures and the production are high. So the subsequent evidence, the evidence after Petrotrin took over the field from A&V, the measurement and the figures of the production of the oil in the Catskill field and the A&V wells continue to be high. These 5 to 6 wells in a cluster produce oil together, and there were clusters of these wells, so you had several wells pumping and providing oil at the same time, so there was a greater volume of oil production being produced by A&V at any given time. A&V was the only independent contractor which employed the cluster wells drilling program. A&V was able to extract more oil in a shorter period of time than any other independent contractor or Petrotrin in the 70-year history at the capsule field. That is a matter of record. It's a matter of history. A&V's contract with Petrotrin provided that any dispute between them would be determined by a three-phase dispute resolution process. Firstly, negotiation, secondly, mediation, and finally by arbitration. A&V, in its lawyers' letters to Petrotrin, activated the negotiation phase and tried to have meetings with Petrotrin to discuss the allegations and for A&V to give explanations and answer to any questions. Whilst in the negotiation phase, Petrotrin, by letter dated the 19th of December 2017, terminated A&V's contract. We continued the negotiation stage in early January by having a meeting with Petrotrin, and at that meeting requested that the termination notice be withdrawn and for the contract to be continued until the negotiation, mediation, and arbitration phase continued. A&V was prepared to give whatever undertaking was reasonable to Petrotrin so that the status quo of the contract would have been maintained until the matter was determined by arbitration. Petrotrin refused. A&V informed Petrotrin that if interim relief was not granted, A&V would be constrained to apply to the High Court to get interim relief to preserve the status quo. A&V was advised that going to the High Court to get an injunction was a risk because the law is that the court normally does not grant an injunction in a breach of contract case where damages would be an adequate remedy. So when we went to the High Court and we went to the Court of Appeal, the court told us that if this contract was wrongfully terminated, A&V would be compensated by Petrotrin, is entitled to damages. So neither the High Court nor the Court of Appeal had to determine the merits of the breach of contract or the merits of Petrotrin's case or the merits of A&V's defense. All it had to determine was whether it should give an interim injunction to preserve the status quo of the parties, and the court took the position that no injustice would be done because A&V can get damages after. A&V decided to try the Privy Council. So we filed an application to the Privy Council. We did not have a right of appeal to the Privy Council, but the Privy Council has jurisdiction in order to determine, to grant leave if there is any point of law of public importance. We went to the Privy Council, we filed an application. The Privy Council gave a judgment saying, well, it made an order saying, again, not determining the merits of the matter, but what it said, there was no point of law of public importance raised because obviously the Privy Council was taking the position that if you do not get an injunction, you can get damages to compensate you. So we had a situation, therefore, in which although A&V, its contract was wrongfully terminated, although it was suffering loss of reputation and severe damage, although Petrotrin was retaining monies, about $80 or $90 million which it owed to A&V for the supply of oil, A&V had to battle. So it was battling. So the only resort A&V had was to go to arbitration. Now those of you who do not know it, in contracts normally it provides that if there is any dispute, there's a resolution process which includes arbitration. What that means is that the case does not go to the court to determine the merits of the case. It goes to arbitrators. So that matter is now before arbitrators, and I will tell you, the arbitrators are very powerful people in this case. It's not no ordinary arbitration. The chairman of the panel of arbitrators is the president of the Caribbean Court, former president of the Caribbean Court of Justice, the Right Honorable Sir Dennis Byron. The other member is the Right Honorable Lord Hope, a former judge of the Judicial Committee of the Privy Council. And the other member is retired Justice of Appeal Humphrey Stallmeyer. So we have basically a very powerful team of arbitrators. Now, I am now going to deal with some of the reports and information which Petrotrin had after it terminated the contract, which the contents of these reports and information supports A&V. There's a report known as the SGS report. The report was commissioned by Petrotrin. It's an international company, and that company was asked to review both the internal audit report and the supplemental internal audit report. The SGS report in its findings stated that Petrotrin's measurement systems of crude oil supplied by independent contractors to Petrotrin were deficient and defective. At paragraph 211 of the SGS report, it concluded, but Petrotrin ought to upgrade and modernize its equipment, and if it did not do that, it runs the risk of exposure and error and mismeasurement, both of which are expensive and can dent the company's reputation. So what this report is saying, that your system is not good. If you do not correct it, it could be expensive. That means you will probably have to pay a lot of damages for decision you make, and it can dent the company's reputation. Petrotrin had this since December 2017. They never disclosed it to A&V. They never disclosed it to the court, and we are taking steps to make it disclose, to make Petrotrin disclose this formally to us. What this report is talking about is a measurement system that Petrotrin used to measure the crude oil sold by A&V to Petrotrin, and which measurement Petrotrin is relying on to assume and to infer that A&V overstated the quantity of oil that it sold to Petrotrin. The next matter is a PowerPoint presentation I talked to you about. This was done in September 2018. In early August 2018, Petrotrin received a document from its own engineers and experts in the form of a PowerPoint presentation labeled Reservoir Evaluation of the Catskill Field, which was updated on the 5th of September 2018. The PowerPoint presentation showed that A&V's wells in the Catskill Field were in fact capable of producing the volumes of oil reported by A&V. This is Petrotrin engineers. The evidence which Petrotrin got from its own experts and engineers undermined Petrotrin's case against A&V, because the major plank of Petrotrin's case was that the wells did not have the capacity to produce the oil A&V supplied to Petrotrin. Petrotrin's own experts and engineers are now stating that the wells had such capacity. The presentation also stated that Petrotrin re-evaluated, that is the experts, re-evaluated and remapped the Catskill Field, that is where the oil was being drilled, in the light of new information of the production volumes of wells previously drilled by A&V, which were being operated by Petrotrin. The remapping depicted what A&V always stated, namely that the Catskill Field was highly faulted with many separate blocks and with many sands, that is, different layers of oil reservoirs underlying those separate blocks. The PowerPoint presentation also showed that the portion of the Catskill Field operated by A&V had a large oil reservoir capacity. The contents of this PowerPoint presentation therefore showed that Petrotrin was wrong to assume that A&V wells did not have the capacity to produce the crude oil it sold to Petrotrin, and therefore the basis for termination of A&V's contract was destroyed. When I saw this evidence, and when I saw Petrotrin suppressing the evidence, I wondered whether there was somebody at Petrotrin. I asked myself the question, is it true that somebody at Petrotrin knows the potential of this field and therefore they would like to get it out of A&V's hand and give it to them or one of their friends? Because I cannot understand, and I still cannot understand why a state-owned company would have all this evidence and close its eyes to it and go ahead and terminate a contract, and it does not take steps to restore the contract. This remapping took place between July and September 2018 after Petrotrin took over the field in March 2018. And the information Petrotrin found through its experts and engineers is consistent with the quantity of crude oil which A&V sold to Petrotrin. This evidence alone conclusively demonstrates that Petrotrin's termination of A&V's contract on the basis that the captive field were incapable of producing the volumes of oil was plainly wrong. But members of the media and my fellow citizens who are listening to this, that is not the end of the picture. Let me tell you, I'm going to something else. There was an email from Gaffney Klein and Associates to Petrotrin. You remember Gaffney Klein and Associates was the expert, the company that Petrotrin Board of Directors went public and said they were having an independent investigation, and they were given to Gaffney Klein all the information in order to advise it what to do with this contract. Well, in early August 2019, A&V got sight of an email from Gaffney Klein and Associates, which was sent to Petrotrin. That email suggested that the data which Petrotrin gave to Gaffney Klein before Petrotrin terminated A&V's contract was inaccurate. Gaffney Klein was telling Petrotrin that the maps and information now sent to it shows that the first opinion it gave was based on inaccurate information. The email stated, and I quote from the email, "Hollis, about the map you sent today, that this is information that was not disclosed in our visit to, on our first report, and it has important details. I have some questions for Petrotrin. The area is strongly faulted. Are these blocks created by these faults, isolated blocks? Because in that case, the argument from the other side, that meaning A&V, about the drainage area will be difficult to rebut." That is Petrotrin's own expert, Gaffney Klein, whose reports Petrotrin did not want us to see, but we saw it. And now we are seeing the email. This email made it clear that the maps which Petrotrin now provided to Gaffney Klein and Associates, which Gaffney Klein and Associates did not have when it did its first report, had important details to show that A&V wells at Capsule Field had the reservoir capacity to supply the crude oil that A&V sold to Petrotrin. In other words, Gaffney Klein was telling Petrotrin that Petrotrin misled it when Petrotrin gave it the information for its first report, and which Petrotrin used to terminate A&V's contract. But the new information from Petrotrin was totally different to what it got before, as it showed that A&V's wells at the Capsule Field had the reservoir capacity for A&V to sell the oil it sold to Petrotrin. Further, Gaffney Klein and Associates stated at paragraph 4 of its email, and it gave an opinion as to Petrotrin's measurement system, which it used to measure crude oil sold to Petrotrin by independent contractors. And Gaffney Klein said that the system is largely manual and there was a high likelihood of measurement errors in that process. Now there are other reports, many others which we have seen, too numerous to mention. But other reports consist, and I'll explain it to you. Petrotrin has something called the Petrotrin overages reports. And those reports show the same kind of oil production in the field at Catskill, the same kind of variation. So those reports will negative any assumption or inference. It has something called, some reports called the well test reports data. We have seen some of that. And those well test report data also show that the Catskill field has the reservoir oil capacity to produce the oil which A&V sold to Petrotrin. This is a very serious matter. It is a very serious matter because members of the board, of the then board of Petrotrin, which is a state-owned company, use the position and the power of the state to take away the lawfully entitlement to A&V. And I am not making any threat today, but I have a duty to my client to explore whether the members of the board at the time did not commit the tort of misfeasance in public office. Because in my view, there is evidence of recklessness, gross negligence, and an attitude of not interested in the truth. It is very serious for state companies to deny persons their contractual rights. And it may be, I should say something about that. I would hope that the government of Trinidad and Tobago would take steps to ensure that the information which I have disclosed today and which probably the government is not aware of. I see that there is a new board of directors of Petrotrin, but if I were a member of that board, I would have a duty to call for all of this information and for the board to look at it. And state corporations, the government must send a signal to state corporations that they are occupying the positions in trust for the people of Trinidad and Tobago and not for themselves. Finally, the arbitrators have a decision to make in January. I want to tell you that we are equipped. We have international experts. We have requisite legal expertise available for the arbitration, and we are ready and willing and anxious to see the evidence which Petrotrin would call to give evidence, and we are ready to cross-examine that evidence and show to the arbitrators that there was no basis for the termination of this contract and that this is a frivolous defense being put up by Petrotrin to deny A&V its entitlement. This is a case in which the damages would be very, very, very large. Thank you very much, members of the media.
The leader of the opposition, MAHARAJ S.C, she bust them out that APM was supplying fake oil, Petrotrin. From what you have said, it's a lie.
Yes, well, not only to anyone, but to anyone who contends it's a lie as far as Petrotrin is concerned. It is a lie that if anyone in the government thought that this was fake oil, it's a lie to any member of the media who thinks this was fake oil. It is a total lie.
Well, Mr. Maharaj, what action can be taken by the APM against the leader of the opposition for moving forward that way?
Well, there is a case pending in the courts in which A&V has file a claim for defamation in respect of the statements made, and our case was based on the fact that this was a private and confidential report, and that it should not have been disclosed, and we are saying that the publication of those words are defamatory. But I am not defending anybody, but it may be that what happened is that the leader of the opposition erroneously relied on the contents of an internal audit report, which turned out to be inaccurate and unreliable.
Mr. Maharaj, do you think that you're saying that about the opposition leader, but do you think that there was a conspiracy by officials from Petrotrin and other agents to use the info to furnish the opposition, because we all heard it first from the opposition leader, to furnish the opposition leader with this information, knowing that it was totally untrue, to discredit? Do you think that there was a conspiracy to destroy the opposition while destroying your client?
Well, that could happen because I used to be in politics, and people will give you information, and if you just use it, you can get yourself in difficulties, especially if you use it outside of the parliament.
Just two questions before we continue. I realized that in number 29 is 36, where Petrotrin took over the field in March 2018. Now, when they took over the field and they had terminated the services of your client, but when they took over the field, you said, based on your investigation and your report, that they were making almost similar to what A&V was making after, with respect to the 48 wells and whatnot. But tell me something. If A&V being the contractor, they would have had to employ, because I believe that there are about 40-something other contractors. So then, was it that they had to get rid of A&V, seeing that he did all this work? So who are the contractors? Would you tell us, if you maybe, I believe you have that information, that who are the contractors that replace A&V?
No contractors replace A&V because Petrotrin kept the field for itself. But Petrotrin was drilling oil.
But how I heard personally that there were attempts to bring friends.
It may be, I also heard certain things, okay. And it may be there was a plan to bring in other people, but we were very aggressive because if, for example, Petrotrin had given that field to another contractor, remember in our claim for damages, that would have heightened the claim, because the tribunal has the power to make orders that it considers fit. So the tribunal can make an order for damages. It can also make an order for him getting back the field, for Petrotrin taking steps.
What is loss and everything?
Oh yes. That.
Could you tell us, I mean, you might not disclose figures, and you said in closing that the damages will be great. You want to give us an idea what the damages?
Talking in terms of about $1 billion.
$1 billion. Okay.
This is a major claim. Yes. Yes. Well, I don't think that question should really arise in this matter. What I could tell you is that I feel very strongly about this case. I feel as if this was an injustice to me, and it is not unusual for me to feel that way in respect of some cases. And since I consider it to be an injustice to me, I suppose I have a lot of passion, extra passion for it, and that is only human. But I would ensure that A&V and Mr. Baksh get the justice they deserve.
See, we are live, everybody's watching all over the world. But one question somebody said to me is that now in your field as a senior or a prominent thing, you're a very distinguished man.
Oh, thank you very much, sir.
But in the field with Petrotrin, in the area of Petrotrin, Gaffney Klein a distinguished organization, that individual, that you know.
Yes, Gaffney Klein is a reputable company. It's a reputable company, and I think that I think that probably explains Gaffney Klein's
request for more information.
Well, it explains Gaffney Klein's email in the way they said that they were misled.
Do you think that Petrotrin, as we say in local parlance, they try to chain up Gaffney Klein and furnish Gaffney Klein with false information?
Well, you have to understand the position Gaffney Klein was in. And Gaffney Klein made it clear that it was relying on the data Petrotrin supplied.
But then the document said that Gaffney Klein realized that he was fooled.
Yes, because, yes, they realized they were fooled when Gaffney Klein got further information from Petrotrin. In 2019, Petrotrin, probably by error, supplied some of the information of the mapping of the area, which was done because of the PowerPoint presentation. And when Gaffney Klein saw that, it realized that it was probably fooled, and that is how they raised it with Petrotrin.
But do you think, before I give Hollis that question, do you think that this government will use your client as a scapegoat, a fall guy, to say that the amount of money that A&V took from Petrotrin, we have to close it down?
Well, A&V did not take any money from
Do you
Petrotrin.
think that they will come with that?
No, I think A&V has rights. The government cannot do that. The government cannot do that.
Like that, because you hear workers saying that will know there's all this racket and this fake thing and whatever. Now you hear truth coming out now that, I mean, it's frightening. I mean, how do you describe this whole event?
Well, I would hope that any government, whether it is a P&M government, a NAR government, a COP government, a UNC government, a partnership government, any government, seeing these facts, and regardless of whether the person is a supporter or not a supporter, ought to take steps to ensure that the person gets justice, because the miscarriage of justice to this person is not his fault.
And in closing, with respect to what I'm asking, the question I have here, you said damages after the arbitration. How long that process takes?
Well, this is a very powerful team of arbitrators, and I think that you'll get a very quick judgment in this matter. The arbitration would be heard in January, and I think by the month of March, there'll be a judgment.
Based on the findings and whatnot. Thank you, sir.
I am not saying that the Kroll report was not an independent investigation. I am not saying that the Klein report was not an independent investigation. What I'm saying that the information which Petrotrin gave to Klein, although it's a very reputable company, it showed that they were limited because they acted on inaccurate and unreliable data. I do not know whether Kroll got the same data. I haven't seen the Kroll report. I do not know what the Kroll report says. But all I can say is that even if you have the Kroll report, you have other reports now which show that, one, the field has the capacity to produce the oil A&V said it produced. The Petrotrin records have the pump that has the capacity. The measurement system is flawed and cannot be relied upon. So I cannot see how Kroll could help in this in any event. But what I do not understand, and there's a principle of law, is that if I suspend someone or I terminate a contract on the basis of the contents of a report, I have a duty to make that report available. If you are refusing to make that report available, the law says that the court can draw an adverse inference against you, that you have something to hide, and that the report does not support you. And the court can find that the reason that you did not make it available, and you do not want to make it available to the court, is because the report does not support you. So the Kroll report cannot assist Petrotrin at this stage, having regard to the totality of the evidence from Petrotrin itself, from Petrotrin's experts and engineers. That is why I could come before you today and say that I'm 150% sure that there could only be one result in this case. And the persons who are going to judge this case are persons who have long history. Lord Hope is one of the most eminent jurists in the Privy Council. Lord Byron is also one of the eminent jurists in the Caribbean. When you read his judgments, he does not make joke when he sees unfairness and injustice. Lord Hope is not going to tolerate unfairness and injustice. And I have no reason to believe that Justice of Appeals Tolmaya would tolerate unlawfulness, unfairness, and injustice. Sorry? Well, I think it's the final step, but there's a school of thought which says that if there's an error of law, the Court of Appeal has jurisdiction. Only on an error of law. But that's the end of the matter, if it is. But Mr. Warner is so happy to see you. You like my brother, man. I haven't seen you a long time. And anyhow, Mr. Warner, as you know, any government which has a judgment from a tribunal like that, which would paint the picture, which must paint the picture of the evidence, it would not be politically wise for such a government to allow a state corporation like Petrotrin to pursue such an appeal. I know, I agree with you, but I still have confidence. Yeah. Any more questions? I must say thank you very much. I thank all the members of the media for coming, but it's a long time I did not see Mr. Ian Allen, and it's a long time I did not see my brother Jack Warner. So I'm happy to be here. Thank you very much. Okay. Sure. If
we observe that this match was in the background. We can begin in as much as
I can't compel Mr. Baksh. I do not have any jurisdiction over Mr. Baksh. Mr. Baksh doesn't like the cameras. Come, Rabada.
I'm here.
no.
Sorry.
Okay.
The only person missing is right around.
It's who? It's who? No. He just can't force it.